Hi, I'm Dave Chaplin. I'm the CEO of Contractor Calculator and IR35 Shield.
Hello, and I'm Keith Gordon from Temple Tax Chambers.
We're going to discuss the Kickabout ruling that came out in the decision came out recently. We did have two videos that we recorded recently, and we both watched the case, and we made some predictions about what we thought the decision would be. Keith, can you get us up to speed with this case and what it was about and how we're getting to where we are today?
Yes, certainly, Dave. This was one of a number of cases involving media presenters, television and radio presenters, and challenges by HMRC that the IR35 rules apply. Now, the IR35 rules are there to stop someone who is technically an employee trying to avoid the consequences of employment law and the PAYE national insurance contribution rules that apply for employees by interposing between them and their employer a limited company or other intermediary, so that effectively that intermediary breaks what would ordinarily be an employment relationship. And what the IR35 rules do is say, well, when you have an intermediary, you then try to work out what the relationship would be between the worker and the putative employer, and work out what that contract would be in a hypothetical world, and ask, is that an employment contract? So IR35 is a shorthand nickname for all these rules. And this case was one where an individual named Paul Hawksbee presents a radio program and has done for a number of years on Talksport radio. And he provides his services through a limited company called Kickabout Productions Limited. And the question was the relationship between him, Kickabout, and Talksport Radio, if you cut out the Kickabout intermediary, was he effectively an employee of Talksport Radio? The first tier tribunal said he wasn't. The revenue were unhappy with that decision, and they appealed to the Upper Tribunal, who, in short, said he was.
So the Upper Tribunal decided to, I guess, override the decision. And there was a number of options available to them. They could have dismissed the appeal, in which case they would have agreed. They could have said, well, we're going to put this one back to the first tier because we'd like them to consider it again. But in this instance, they remade the decision. Is that something that's quite rare to happen at the Upper Tribunal?
Actually, I would say that remaking a decision seems to be more common than the alternatives. When, well, either they uphold the original decision or they remake it themselves. In order to get to the stage of remaking a decision, the Upper Tribunal has to decide that there was a fundamental error in the original decision. In other words, the original decision can no longer stand, has to be set aside, and then the Upper Tribunal has the decision: do we remake it on the basis of the documents and information before us, or do we have to send it back to the first tier tribunal, either the same or different set of judges, to remake it? And increasingly, I'm seeing the Upper Tribunal feeling bold enough that it has enough information to remake the decision, which in many ways is not a bad thing, because it saves you the risk of yet another hearing and the cost of another hearing. And indeed, it's the first tier tribunal stage, which is often the most expensive, because that is the longest stage, which requires the most preparation, with witness statements and evidence. Now, strictly speaking, if you're just remaking a decision, you don't normally need to have all the evidence again. It depends on what the error that the first Upper Tribunal has discovered. But if it's a case of a small technicality, then the first tier tribunal can simply pick up where it left off with a slight correction. But equally, in those circumstances, it's probably, in most cases, appropriate for the Upper Tribunal to make the decision. It depends on whether the first tier tribunal has done its complete job. So I can get into more technicalities about this. But what happens is, if a first tier tribunal says, well, for employment, we need to go through three stages: personal service, stroke mutuality of obligations, secondly, control, thirdly, then the balancing exercise. And I'm using that as a short overview of those three tests. If the first tier tribunal says there was no obligation for personal service, therefore I do not need to discuss questions 2 and 3, that might be the end of the appeal. The appeal's been allowed by the taxpayer, but allowed in the favour of the taxpayer. The revenue appealed to the upper tribunal to say, well, that was completely wrong. There was a requirement for personal service. The upper tribunal in that situation hasn't got the benefit of any findings of fact or even summary of the evidence about the other aspects of the test. So in that case, it would have to go back to the first tier tribunal. But in this, what usually happens is the first tier tribunals usually come up with a comprehensive finding of facts and analysis. So even if they're found to be wrong on one part, it doesn't mean that everything they have done has gone to waste. And that's what's happened here.
In the last video that we did, we recorded that in the evening after we'd actually watched day 2. We watched the 2 days of the tribunal in the court, which was a remote hearing. We made some predictions, and we made sort of 4 main predictions. The first one, we both said that we didn't think it would actually be won by HMRC. The appeal would not be successful. So we were wrong on that, and we'll go into details as to what happened there. We weren't sure whether this whole thing around clause 8 would feature or not. This was really around mutuality of obligation. The other thing that we were keen to see was whether or not the professional referees case and the ruling on mutuality of obligation there would be overruled, because during the hearing, HMRC counsel were making an argument that that decision was wrong. So we were keen to see whether that would be reinforced. And then one of the big points was that you wanted to see whether or not the Hall versus Lorimer stages would be correct in terms of the balancing exercise and so on. And I think that one stood. So firstly, before we go into those points, were you surprised at the ruling and that it was overturned?
I think I was possibly more disappointed rather than surprised. It's actually quite an interesting decision, and in fact, it probably would make a very good case study on how things can proceed in the tribunal system. Because what happened is that the majority of the upper tribunal's decision is focused on a very minor technical point that is of very little relevance to any other case, because it's a very fact-sensitive point. And what had happened is that the revenue said the first tier, when analysing the contracts under which Mr. Hawksbee and Kickabout were working, said that there was no obligation on Talksport radio to engage Kickabout / Mr. Hawksbee. Now, personally, I couldn't quite understand why the first tier had actually reached that decision. It was a very techie point. It was one which just did not look right to me. But the revenue put their emphasis, well, on that argument, and actually they found 7 other complaints about the fact-finding of the upper tribunal, of the first tier tribunal. And usually you can't challenge facts, but if you can find that there's been a finding which is perverse in the light of the evidence, then that can still be challenged in the upper tribunal. So the revenue had 8 main attacks on the first tier's decision.
So do they just have to get one of those right, or do they have to get all 7 right?
Well, in this case, they found only 1. It depends on what the error is. But I was trying to liken this to I don't know whether you actually still get this in supermarkets, but you certainly, when I was growing up on television comedy programs, you imagine a supermarket with a pyramid of cans of baked beans, where in the typical slapstick fashion, someone will take one from the bottom with a view that the whole pyramid will collapse. Now, with your scientific background, you will know that generally, if you pull one out, it won't actually collapse. But in this case, the finding that the revenue managed to get overturned was this rather curious one. And it was considered by the upper tribunal, and I think correctly, to be fundamental to the entire case. Because if you've got a finding that the upper tribunal or the Talksport radio was not obliged to provide work to to Kickabout, stroke Mr. Hawksbee. That is so fundamental to one's understanding of the relationship that it does pull down the entire pyramid. If it had been something of a much more minor point, for example, suppose the written contract had said he was required to provide services on 222 days, which was what it said, but the tribunal said 225. Just it somehow misread the number. That would be an error of fact, which theoretically could allow the decision to be set aside, but it would be so trivial in the overall scheme of things that that wouldn't pull the pyramid down.
So when they were looking at this, that was the first ground, wasn't it, that they were saying wasn't right? That was the that clause 8 that was in contract 2. There were 2 contracts, and in the second contract, it said in the main body of the contract that there was no obligation to offer or provide work. However, in the schedule that they agreed to, there were a minimum of 222 programs that needed to be done per year. There were some arguments to say that perhaps the contract was a sham and so on, and they might have invoked auto-cleanse, the ruling which enables clauses to perhaps be set aside when there's unfair bargaining power. But in this instance, the judge said, no, actually, the argument with regards to auto-cleanse is not the one I'm going to use. This is a matter of law, and reinterpreted the contracts to say, well, no, there is actually an obligation to offer and provide work, and that correct me if I'm wrong here, but the clause 8 was about what was essentially saying there's no necessary need to offer or provide work, but once it has been offered and a project is in place for 222 days a year, that's the bit that we need to be looking at, and that's where the obligation came in.
That's absolutely right. The Revenue tried to rubbish clause 8 on auto-cleanse route and failed. But interestingly, you'll remember during the actual hearing, most of the argument was on clause 8, and they were focusing on the second contract or second set of contracts, whereas the tribunal started with the first. Now, I think one could look at clause 8 critically and say it was there in order to give the semblance of a lack of mutuality of obligations. That might have been its purpose. We have no idea. But the Upper Tribunal said, we do not like what the first tier has said, and actually we don't necessarily agree with it. And I think I have to accept that was completely right. It was just, if one takes a step back, the entire argument was to show that there was no mutuality of obligation. And in the cases that I have advised on in IL35, in virtually all of them, I have said that the mutuality of obligations argument is not a strong one. It's not where you should be putting your emphasis. But it took most of the arguments before the Upper Tribunal. So the Upper Tribunal had, I think, fairly good reason to set aside the hearing, set aside the decision. But then it meant there was little opportunity for the taxpayer to say, but let's look at the other aspects of ready-mix concrete, the control and sort of the third stage. And they were already, by that stage, they were well on the back foot. And the Upper Tribunal, having decided to make the decision itself, remember the taxpayer asked for it to go back to the first tier tribunal, it was almost a case of inevitability. And I think there were issues in the Upper Tribunal's analysis on the other points, but it didn't get much of the airtime, and therefore you can't really criticize the Upper Tribunal for making the decision it did, because it wasn't fully argued, at least in oral submissions, whether or not it was covered adequately in the skeletons. I don't know.
I believe there was one argument, if I remember from when we watched it, whereby HMRC counsel were arguing on mutuality of obligation, using this same old tired argument that all it means is someone is going to get paid for doing something at some point, essentially just consideration, the irreducible minimum, without saying there needed to be any necessary sufficiency. And it was it Judge or Justice? Justice, do I use the phrase justice? Justice Zaccaroli. Justice Zaccaroli.
Justice.
Mr. Justice. He essentially was asking, well, did I make the wrong decision then in the professional referees case? Because in that case, it clearly lays out that there needs to be a bit more than just being paid to do something. And HMRC were trying to argue that that was wrong. But unfortunately, so we were looking forward to the decision to see whether there would be any commentary on that. And there was nothing there, well, other than say they didn't need to comment on that.
Exactly. And that also relates to the point about whether Hall and Lorimer has been wrongly applied over the last 25 years in all of these cases. One of the other areas which we eagerly looking forward to some clear judicial analysis.
What was HMRC's argument, if you could just remind us, that was contrary to Hall versus Lorimer? What were they saying at Upper that you had said, well, that can't be right?
Well, there were 2 points. The first is that you don't actually apply the paint-a-picture approach at all. It's only appropriate in whether you're carrying on a business on your own account, and this isn't a business. So first of all, it's just not applicable in this kind of case. And secondly, they said, even if you do paint a picture, you ignore from that picture anything to do with control or mutuality of obligations, because they are part of the first and second test of ready-mix concrete. So when you're looking at step 3, you don't consider those points. Now, it would have been nice to have those properly addressed. Now, the first one, I think you could possibly say the Upper Tribunal implicitly ignored it, and because they did effectively apply a more or less classic Hall and Lorimer approach to painting a picture. They had the number of characteristics which were in favour of employment and those which were neutral and those which were against. And they sort of did a balancing exercise. It's probably slightly different nuance, but effectively that's what they did. And they said, we don't need to decide whether or not you do or don't count control or mutuality of obligations in that analysis, because on either basis, you don't win.
So I assume we are still saying that nothing's changed with Hall versus Lorimer based on this decision. It's sort of back to the way everyone knows it, because they didn't really comment on that in the decision that it needs to be done differently.
I would like to say that officially nothing has changed. However, it is possible that the revenue will say, this is now the definitive application of stage 3 ready-mix concrete, and they will try to go for a carbon copy approach by saying, well, your facts are similar to this, therefore you're going to fall down on that 3rd stage in the same way as Kickabout.
I think people could argue that actually their facts of their case, particularly with presenter cases, aren't the same as the Kickabout case. It really was quite unique.
I would say that, and I would certainly hope that, but on the specific points that the Upper Tribunal considered, which were the same as the first he had considered, they were pretty standard. So one's going to have to be quite robust. I'm not saying it would be difficult to do, but one will still have to be quite robust into ensuring that the revenue don't then try to use this as the template for all future decisions.
I noticed that the judge, the tribunal used the phrases for stage 1 and 2 of, now we have got to the stage where there is sufficiency of mutuality of obligation and sufficiency of control. As opposed to saying in stage 1, we've got to personal service and there is an irreducible minimum, and now we go on later and see how sufficient that is. Would I be right in saying there is a measure of how much mutuality of obligation at stage 1, and if it's insufficient, we don't go any further, but if it's sufficient, then we keep going. And then for the amount of sufficiency will go in the pot at stage 3.
That's how I would say it. Now, personal service, you can either have it or you can't have it. I don't think you can sort of have any degrees of personal service. The mutuality of obligations, I take a view which is not universally accepted in the tax community, but I take the view that it's a fairly low threshold at that stage. Remembering personal service, well, not quite the exact words of Mr. Justin's Ken in Ready Mix Concrete, but that's a clear point that one can take from Ready Mix Concrete. The concept of mutuality of obligations has sort of evolved out of that same phrase. Control is a point that you have to have to a sufficient control, to a sufficient degree at stage 2 of Ready Mix Concrete. But then you've got the point when you come to the balancing exercise or painting the picture in stage 3, whereas the revenue would like to cast that all aside. And that's where I fundamentally disagree with them, because I say that, okay, you've got sufficient mutuality of obligations because, for example, there is on any particular gig, whether you're doing for 222 days of the year or whether you just simply booked for one session, clearly you have a mutuality of obligations to provide the work on that one session. But surely, when painting the picture, you must then ask yourself, well, how secure is this? Is this just a one-off gig as an individual incident of self-employment, or is it effectively a permanent job? That's why I say it's extremely important and relevant to be considered, and that's why CEST is wrong. But it has to be taken into account at stage 3. But you can see why the revenue are so keen to get it cast aside altogether.
It's interesting because there needs to be some sort of understanding for an employment as to whether there's some sort of guarantee of work and how it finishes. So typically when people talk about mutuality of obligation, they talk about, well, is there any mutuality of obligation outside of what's agreed? Really referring to, is there any sort of ongoing obligation to provide more work? And then let's look at mutuality of obligation, so essentially in the currency of the schedule that's been agreed. But in this instance, they sort of looked at it, how will it finish? I think there's something about how will this engagement finish? Because what was fatal to the sort of interpretation of Clause 8 was the fact that there was a 4-month termination notice in the contract, well, which was completely at odds with the idea that there was no need to offer or provide work. You wouldn't need a clause that said that. And in an employment, can't just finish willy-nilly and terminate on the spot, whereas if you're self-employed, you can. And that appears to be a lesson that we all just need to learn again, perhaps, from this case.
Absolutely. I think this is one of those areas where the whole of the argument was very narrowly focused on this Clause 8 or the previous version of the contract. And normally I would say, don't put too much emphasis on mutuality of obligations, focus on control and focus on the balancing exercise. I was sort of rather dissatisfied with, actually, we'll talk about the reason I'm dissatisfied with that part of the decision later. But I think one of the other points, which you might remember we were discussing after, possibly even when we had our chat before the hearing, that one area where we felt the first tier tribunal decision was weak is that it didn't seem to have applied stage 1, stage 2, and only if those were passed to go on to stage 3. It seemed to put it all into a general mix. And the revenue also took the view that the tribunal didn't actually apply ready mix concrete correctly, in that it just put them all into the mix. But the upper tribunal said, well, it must have done. It discussed mutuality of obligations, it discussed control, and it went on to discuss this third stage. And if it discussed the third stage, it must have assumed that stages 1 and stages 2 were met, but there was no express finding to that effect. It was, as I said, I wouldn't have focused on mutuality of obligations, I would have focused more on control. Because the upper tribunal had assumed that there was a finding of control, it sort of said that that test has been passed. But all the first tier had really done on control is said, well, there are some aspects of control, there are some aspects where there's no control. It didn't come to a bottom line saying, we say that there is control to a sufficient degree to make someone master or an employer, to use more modern terminology. Whereas the upper tribunal said, well, it must have reached that conclusion because it went on to stage 3. Therefore, we're going to support the finding on stage 2. There are aspects of control. But yes, of course there are aspects of control. But is it sufficient to make someone master? Now, if I continue with that, it said, well, just think about it. Professional footballers and surgeons are not controlled to that extent. They have their own opportunity to use their own skills, knowledge, and intuition. So it's completely true that a skilled individual isn't micromanaged by the employer. But is that sufficient to make someone, does that mean there's sufficient control? No. One has to look at the whole picture. And I'm not looking at the picture for stage 3, but just generally, what is sufficient control to make someone master? Why is a footballer an employee, even though they have their own flexibility to an extent as to how they perform? Well, it's because they're a member of a team. They play when they are selected. They have to play in the position they're selected. They have to fit into a general pattern. You can't be the centre forward and put on a green jersey and stick yourself between the posts. You haven't got that much control. And a surgeon, whilst they clearly he or she will use his own or her own skills as to decide whether a particular patient should be operated on or not, or in a particular way. But there's still the framework that the lists are given to the surgeon by the employing hospital. So that's what puts someone under control to a sufficient extent. Whereas the upper tribunal seems to have said, well, you're skilled. Well, that's not enough to make you, stop you being an employee. There is some element of control, i.e. the editorial control held over you. Therefore, once there's an element of control, that's sufficient. I think that's wrong.
The whole control topic for these presenter cases, it's very contentious, and there's lots of debates going on about creation of the output, control of the output, editing the output, who owns the output. And there is an argument at the moment to say that just because someone can cut off the output being created by the performer, that therefore means they're being controlled, which I find odd. And in this decision, which I thought was quite worrying, there was this whole framework of control thing. It's an argument that's often used, isn't it? In most cases on control, once the how element is considered to be neutral because it's a skilled person, it often comes down to the what. The what is very, very important. So typically, I would say in an employment, you hire an employee for their box of skills and they come in and you're going to assign them to do things. And yes, master, I'll do whatever it is you ask. Whereas a self-employed person, you've asked them, they've agreed beforehand, this is what we're going to be doing. And they come in and they just do that. And if you ask them to do something else, then quite rightly, they can say no, and there's no obligation on them to do that. Now, you would make that argument about Paul Hawksbee, because he was only doing that show. It was in the contract that he was only doing that show, and they couldn't ask him to go and present something else. But I would argue he's not controlled then, because he's only agreed to do that one thing. But the way I read the decision was that the judges said that they weren't concerned about the narrowness. It was about the framework of control, and essentially framed the sort of area of where control could be exercised based on what he had agreed to do, which was just present that show. And if they do that, and that's the law, then everyone's an employee because you've already agreed up front. It doesn't make sense, does it?
Absolutely. And that's why I was so glad that in Lorraine Kelly's case, Albertel, we got a finding that ITV had editorial control, but ITV did not necessarily control Lorraine Kelly to a sufficient degree. So editorial control does not get you home. And I go back to the example I keep on harping on about. Imagine you've got someone, Benedict Cumberbatch, has been asked to take a part in Hamlet for a 12-month run in the West End. Now, he can't control what he says. That's already been dictated 400 odd years ago. He can't determine necessarily what to wear because that's been decided by the production team. He can't decide where he speaks. He can't decide necessarily who is going to be his Ophelia. he's got absolutely no control as to what he does, says, how, where, when. He is totally, for the performance, under the control of others. But he is not an employee because he has chosen to take on that role. Now, if they said, oh, by the way, we're going to take a 2-week break in December, and we're going to put on Puss in Boots, and we want you to play the Dame. If they said, well, under your contract, we've got you for a year, we can therefore make you put on drag and play the Dame, then he's probably under control. But if he says, wait a moment, I've been booked for the run of Hamlet, and if you're not putting on Hamlet, then I'll come back to you in January. That's what control is all about. And the point was made quite clearly in the Court of Appeal back in 1984 in the case of O'Kelly and Trusthouse Forte. And the Master of the Rolls, Sir John Donaldson, made the point very clearly that these waiting staff, who were found to be self-employed, one of the key distinctions he drew between the waiting staff and other employees of the hotel is that the other hotel's staff could be deployed on any other aspect of the hotel's business. Whereas if you have been booked for a 3-hour session or 6-hour session to work in the ballroom one night, you can't be made to clean up the bedrooms at the same time.
Exactly, and staying with the actor scenario, and this is where it sort of overlaps a bit with the mutuality of obligation part. If the theatre had said to Benedict, actually this week we're going to shut the theatre on Wednesday, Thursday, Friday, so you won't be required, he can't just turn up and make himself available on those days and expect to get paid, because he's only getting paid for work done. Whereas an employee, there's this guarantee up front of the employee making themselves available. The employer has said, I will provide work for you to do, but if I don't, you're still getting paid. You're being paid for making yourself available. And that's not what happens with the self-employed. And that's what happened with this particular case. He didn't get paid if he didn't do a show.
I think it depends, to be honest, on the contract and how it's drafted. If it's a case of, we will pay you for a 12-month run, and they then decide, actually, we're going to cancel the performance on a few days because there are not enough people coming in to watch it. Then, depending on the terms of the contract, I think you can still legitimately be paid for the full performance because it wasn't cancelled on your terms. I agree with the general principle you're saying, but I think there are sort of nuances which will turn on a case-by-case basis.
Moving on to some of the other matters in the case, we were going to talk about auto cleanse. Yes. And how that featured, because HMRC were making a strong point on that. And it's auto cleanse is often used to try and throw out the clauses that people don't want in the contracts and aren't particularly in their favour. So what happened there in this case?
The main attack from auto cleanse purposes was on this clause 8 in contract 2. And as I said before, it's a clause that does have an impression of having been inserted to give the impression of no mutuality of obligations. But the revenue were unsuccessful in showing it was not actually meant, but the tribunal was able to find a way of reconciling it with a business sensible approach, which was consistent with its own view that there was sufficient mutuality of obligations. So auto cleanse sort of raised its head slightly, but didn't really get the revenue very far on this particular point. I'm just trying to remember whether there was another area where they tried to use auto cleanse.
They were talking about it, weren't they, when they were reinterpreting clause 8, yes. And whether or not they were going to say there was an offer for work to be, there was mutual obligations. Are we going to override this and say it's because of a finding of fact, or are we going to override it because of a finding of law? And they did it on a point of law rather than a fact find. And I was interested to see the quotation. I can't remember what paragraph it was that referred to the Supreme Court ruling, which sort of says that judges aren't supposed to meddle in contractual agreements that have been made, even if they're completely one-sided. Could you shine a light on that?
Yeah, that was Lord Neuberger in about 2015, saying a contract, this is quite a fundamental part of English contract law, that you're stuck with the bargain you have reached. It might be a bad bargain from one side, but in the absence of any fraud or misrepresentation, etc., you are stuck with the findings. So, for example, if you go down to a car boot sale, supposing such things can happen in social distancing times, go to a car boot sale and someone says, oh, this is just a sort of old painting which we don't really like, it's rather ugly. It's not worth more than 20 quid, but I'll accept tenner for it. And you happen to recognize it as a Rubens, you're entitled to buy it for the £10 that you've been offered, even if you know it's a bad bargain. You've got superior knowledge, but that's your advantage. So when a court tries to interpret a contract, it doesn't then sort of say, well, let's try to reinterpret this contract as if everyone's making a sensible decision based upon hindsight. You can't get the courts to repair a contract for you. And for similar reasons, that a clause which doesn't look particularly attractive can't just simply be swept aside because it doesn't make commercial sense. If it reflects the intentions of the parties, it is a binding term.
Now, and in this case, the contract indicated that the presenter had to essentially do a minimum of 222 shows, but then Talksport didn't have to provide 222 shows. And I think we talked about it before, and I was saying, well, that's just a really bad deal. It's like having a chauffeur and you tell them, stay outside my house for at least 222 days a year, and I'm not going to pay you except when I decide to use you. It's a rubbish deal. I don't know why anyone would go into business with that kind of deal. But yet, and that's what the contract said, but then they reinterpreted those and said, well, actually, come on, let's have a look at this. And it was a bit more of a fact find to say, well, actually, no, you do have to give them the 222 days. It was implied, wasn't it?
It was, but it makes a lot of sense. And whilst the courts cannot sort of meddle with the terms of the contract, they can at least imply terms to give it business efficacy. And the first tier held that whilst Mr. Hawksbee, if he couldn't make some of those 222, wouldn't get paid for them, that if he was ready and willing, then even if he was actually called in on only 200 occasions, he would be paid for the full whack.
So are the judges allowed to, from the findings and fact themselves, imply their own terms into the contracts? I mean, the implied whole term and contract construction thing is the Marks and Spencer's case, isn't it? And reasons when you can do that. But that's like they have decided to introduce something. It wasn't argued by, well, you could actually say it was argued by the parties, but it was, I sense they used a bit of artistic license or you know.
The Upper Tribunal can't suddenly impute facts because that is a job for the first tier tribunal. And the Upper Tribunal didn't actually challenge most of those facts as found by the first tier, other than the question as to whether or not there was this ongoing obligation to provide work. And remember, that's the point which we thought always looked a bit unsustainable. And the revenue just put all their attack on it. And because it was so fundamental, had the effect of pulling down the whole pyramid of cans of baked beans.
So are we saying that fair enough, the baked beans crashed because the mutuality of obligation argument, but that made the crashing of the beans. I don't know how this metaphor is going to work out, but I'm going to run with it. but As they built them back up and reconstituted the pyramid, we're still a little bit uncomfortable with their interpretation of control and where they got to with that.
Yes. And the reason for that, I think, is because they didn't have enough time to hear the full arguments. I suspect that one could say that the Upper Tribunal had formed a view of the relationship. And if you look just at the first findings of fact right at the beginning of the decision, you can understand it does have this air of employment. We've got someone who's been there 18 years providing this service, 3 hours a day, 5 days a week, 222 days of the year. Presented like that, and also the fact that he wasn't allowed to do any other radio work at all. Now, if you just present it in those facts, you can say, well, this looks very much like a typical employment. And I think it wrongly channeled the Upper Tribunal's thought process in that it then interpreted everything else with those preconceived ideas. But with employment law, you can't just simply take a few choice facts without looking at the entire context. And the entire context in this case involved the fact that he was a comedy writer. None of this gets mentioned in the Upper Tribunal's decision, but it's all in the first tier, where as a self-employed comic, he then got this gig, which continued and continued and continued because it was successful. But it then begs the question as to when does a successful gig, this we were talking last time about me doing a routine down the local comedy club. At what point does a regular gig suddenly tip into employment?
And that was one of the points that was discussed about the whole the length of the contract, the fact that it was 2 years, the fact that they'd be doing it 18 years. But there is this real problem, as a point you made actually when you wrote to me about the well, at what point and how do you know? And you can't have any sort of look back provisions. And so I was thinking about this morning, and I was thinking, well, let's say I have a gardener and they also work. I don't know if this is going to work. Let's run with it, because I'm not using sheds anymore. I've upgraded to gardeners. This gardener has been working, let's say, for 10 families in the street doing their gardens for say 10 years. The gardener then so they're clearly in business on their own account with lots of clients, concurrent and so on. But they're getting on a bit now, and they've just decided that they want to retire. So they start taking and letting some of the clients down, and they go from 10 to 9 to 8 and so on, until eventually they've just got one family left, and they're just quite happy to do the garden for that family, which they then do for the next 10 years only. Now they're economically dependent just upon that one family. Does it mean that for the whole of the previous 20 years they were an employee? Have they suddenly become an employee? It raises all sorts of examples where it just doesn't make sense. You'd have to look back.
Yes, but you raise a further point. Suppose you are a jobbing gardener who knocks on the door of number 1, planning to then go to 3, 5, 7, 9, and come down the other side and look at the even numbers of the house street. But number 1 says, you won't believe it, but we've got a huge garden. This will take you an awfully long time. Or perhaps they do number 1, and number 3, number 5, number 7 just simply aren't interested. So despite all their efforts, they have only one job, one client, which might or might not take more time. Now, are they employees simply because they've got only one client? Well, this is another point which arose in the O'Kelly and Trust House Forte case. And the equivalent to the Upper Tribunal is the Employment Appeal Tribunal, or whatever it was called, the Industrial Appeals Tribunal back in the early 80s. Were quite impressed by the fact that these workers, these bar staff, were sufficiently dependent on the Dorchester House because they provide them so much work, they didn't actually need to look for other engagements. And the the appeal tribunal said, well, they must be employees. Well, again, going back to the Master of the Rolls decision, he said, this must involve a misdirection on a question of law, or every independent contractor who is content or able only to attract one client would be held to work under a contract of employment. So just having one client isn't the test, which is why you need that to step back and look at the overall picture. And one would suspect that if all of a sudden, and who knows what's been happening in this COVID world, Paul Hawksbee's contract is brought to an end, he might then start going back to the clubs or doing other comedy work or other radio work or TV work, using his skills. And one successful, long-standing aspect of his self-employment will have just come to an end. So I just feel uncomfortable about the Upper Tribunal's decision, because I think there's just a risk the revenue will try, as I said, to roll it out to other cases. And it just requires someone to say, look, each case must be determined on its own facts. There are no real principles of law discussed in the Upper Tribunal's decision, and simply just treat it as a footnote in the way forward, in the sort of pattern of these IL-35 cases.
That risk is certainly there. I mean, it's any barrister is going to take a point and perhaps argue it and try and use something from somewhere else. But so you think there was anything in this particular ruling that could then be challenged again at Court of Appeal and go further?
If the client has the money, the inclination, and there's enough at stake, then there are aspects that could justify going to the Court of Appeal. I think the question of control would be particularly pertinent. I think you could also get a bit more clarity on the third stage of the ready mix test, whether or not you can actually show an error of law in the Upper Tribunal decision. I think it would be harder. But I think the principal focus, I would say, is go on control.
And what would be the arguments there? I mean, we're still in the realms of you now have to prove there was an error in law at Court of Appeal and then Supreme Court. You can't start bringing in new facts. We talked about that, I think, either in video 1 or video 2. So could they argue at the Court of Appeal, well, actually, there weren't enough facts presented at Upper in order for them to remake the decision, and therefore their error is they shouldn't have remade and they should have passed it back down to first tier. Would that be an argument or not?
It could be an argument in some cases, but we heard that question raised by the judge and the answers from the counsel. I think it would be difficult to say that the tribunal took the wrong course of action in remaking the decision. Whether you put that as a backup argument, I don't know. I think the principal focus was, well, on what basis can you say that there was control to a sufficient extent? You've identified that there are elements of control, undoubtedly. In most relationships, there's some element of control A has over B, but it doesn't mean that it's enough to make that person an employer. So I think that it would be worth challenging that. But as I said, I just have the feeling that there's not going to be enough at stake to justify someone going all the way through to the Court of Appeal.
Are they challenging at Court of Appeal? If you're just challenging just on that one very narrow point, would I be right in saying there's not as much work to do compared to Upper? Because at Upper, they tend to try and create as many grounds as they possibly can and run with it, and there's lots to defend. But if it was just on one narrow point, then perhaps there wouldn't be as much. How am I with that theory?
The theory is great in theory. The problem is, in practice, the revenue can then put in what's known as a respondent's notice and raise all the grounds that they wish to support the original decision, but were not expressly found in their favour by the Upper Tribunal. So they can then rerun the Hall and Norma points, whether or not you should be applying Hall and Norma, and if so, whether control and mutuality of obligations get a look in. So effectively, they can almost try to get the entire case rerun in the Court of Appeal. So what would start off as a narrow, discrete, interesting point of general relevance, and you think, okay, well, we can deal with that in the Court of Appeal in half a day. You might find yourself with a day and a half of argument again, tripling the costs.
So moving forward then, are there real key lessons we can learn from this particular case? And should all of the other presenters, with all those cases stacking up potentially to go in the tribunal, should they all be a bit concerned about this case?
I think they should be disappointed, but not concerned. I think if the taxpayer had won, it would have been a very useful victory for the taxpayer. But this was a case which the revenue won on a very, very minor technicality. Major for that case, but one which is so specific to this particular set of facts. So I don't think they should be overly concerned on that basis. But they do need to be prepared to ensure that the revenue don't use this case as a template. Well, all cases are the same, therefore you might as well give up now.
I mean, are we getting to the position now where how on earth can a presenter be considered self-employed if they've decided to sign up with a minimum number of shows and, okay, they're not there for 18 years, but are they all going to have to be considered employed going forward? I know lots of them are now, have been put on payroll at various places, but should they run scared of trying to be self-employed?
I think I would say that if you're in the identical situation to Paul Hawksbee, it's more worrying. But even so, I don't think the tribunal necessarily analysed all the issues. But if you're someone like Eamon Holmes, where you've got a wide range of other gigs at the same time, and this is where I think the first-tier tribunal went wrong in his case. They didn't actually look at the whole picture. They just looked at that contract, taking the words of ready-mix concrete a bit too literally for my liking. I think in situations where you clearly have a portfolio of work at the same time, rather than just simply you have a portfolio and this is the one job you have for a particular time frame. But if you've got ongoing different gigs, whether it's writing work, other presenting work, that would all help you. And that will take you a long way from this particular case.
I mean, that has to be a thing. I never understood that with the Eamon Holmes case. I know, the classic thing is that IR35 should only be considered on a case-by-case basis, contract-by-contract basis. But he has been in business everywhere, doing all sorts of things for absolutely years. So yeah, it's a strange one, that, and it'll be interesting to see how that one does progress.
Sorry to interrupt, Dave, but I have no problem with IR35 being considered on a contract-by-contract basis. Of course it does, because you are looking at the particular contract and the hypothetical contract which will derive from it. But when you get to the third stage of ready-mix concrete, you have to look at the entire picture. And that entire picture, as Hall and Lorimer is a perfect example in showing, requires you to consider what is your entire work output. Because otherwise, going back to your gardener, if you look only at the work done for house number 1 and ignore the work done for 3, 5, 7, etc., you're going to get a very different picture. You're not showing the true context.
Absolutely, and often you see in cases where the context comes into play by looking at what happened after that particular contract and before, looking at their whole career and painting a picture. And then HMRC might argue, well, forget about those other years. They're not even in scope. We're not worried about those. And they try to narrow it to then get rid of that context, which is important.
Absolutely.
So what, just to wrap up then, what sort of key lessons do you think we can learn from this case, if anything, both for the presenters, I guess, and also from a sort of legal point going forward?
I think the lesson I would have is don't push really weak points at the first tier tribunal. I'm not saying they did in this point, and it just maybe how the first tier ended up coming up with its conclusion. But I personally wouldn't put too much emphasis on mutuality of obligations, other than to show that you've got this inherent uncertainty, which makes you more like a self-employed individual than an employee at third stage of ready-mix concrete. I wouldn't try to say we win at stage one, because what happened here is that the first tier tribunal didn't actually find that they'd won on that first stage, but nevertheless gave adverse findings in relation to that first stage to the revenue, which the revenue were then able to pick at and then pull the whole edifice down.
Would a key lesson also be always make sure you get your contracts drafted correctly?
Yes, but most of the people facing these challenges, those contracts were written far too long ago. And even if you suddenly get wise to it, inserting a term which is helpful to you could in itself be the center of attack as a sham.
Yes, I mean, some of the presenter cases that we're helping with at the moment, some of the clauses in there bear absolutely no resemblance whatsoever to really what's happened on the ground over the years, and they are not in the favour of the presenter from a analysis point on a points of law. And you're sort of left with a bit of a struggle there, because you have to then try to throw out express terms, and essentially I mean, we call it sort of the reverse auto cleanse approach. Yes. And because courts aren't supposed to interfere. And there's all sorts of difficulty.
Whether you call it reverse or forward auto cleanse, there is still the fundamental rule that the contract to be interpreted by the court has got to be what was the actual essence of the agreement between the parties. So there is nothing wrong with a court striking out a term in the written agreement if it does not actually reflect the parties' terms. And at this stage, there is no principle that you can only cut out some types of clauses which are unhelpful to one side. It's not there to protect the worker. It is to satisfy the fundamental role of the courts to determine what is the true agreement. And that's what auto cleanse says. And if you're clever, you can show that the written terms were effectively boilerplate terms which didn't actually reflect your agreement. But it's not always going to be possible to do that. It might be because there's a difference between what you intended and what you actually agreed. And intending A, but signing B, might mean that you're stuck with B, unless you can show that B was really never part of the actual agreement. And it's a fine line.
So if you're fighting a case, defending a case, I should say, would you rather have a great contract and rubbish facts, or a terrible contract? Hang on, am I getting this right? Great contract, poor facts. Poor contract, great facts. Do you see what I'm getting at?
No. Because I'm going to say that the terms of the contract are themselves facts. What do you mean by good contract, bad contract? Do you mean good written, helpful written terms?
Yeah.
So, well, if you've got helpful written terms, but they do not reflect the true agreement, then they're going to be attacked by the other side.
That's no good. No.
If you've got unhelpful written terms, but they don't reflect the true agreement, then you can attack them. What I would like is facts.
Great facts and a contract that reflects those facts. Unfortunately, we see lots of contracts that don't really reflect the facts, and it puts people into all sorts of trouble.
But it also means you can get sent down a blind alley. Because let's say you get the first tier tribunal saying this agreement didn't reflect the parties' intentions, and therefore we're going to substitute certain written terms and say, well, the actual contract was X, Y, and Z. Well, the revenue could go to the upper tribunal and say, well, we're not interested in what the parties intended. The first here made an error of law by being swayed by the parties' intentions. What the first here should have done is worked out what was actually agreed. And I was very careful when I said the intentions were different, because intentions don't get you home. You've actually got to show that the parties actually agreed QRS. And the fact that the written terms drafted by someone else, which you signed in a hurry, said something different, will not pull you down. But you've got to show that what you actually agreed, i.e. both sides clearly agreed. But I think insufficient time might have been spent on these terms because no one actually really looked at them. The most important thing was how many gigs, how much per gig.
I mean, it does seem to be the case in many contractors, and it has happened with the presenters. They just turn to the back of the contract and see how many they're doing, how much, and sign, and just don't read the rest. And it's a problem for them. With this case, then, is there anything particularly hugely impactful when it comes to IR35 for everybody else, or do we just sort of set this one aside? Is there anything we really need to learn?
I think we need to wait for another case which actually focuses more on legal analysis. It's going to be unhelpful for the time being until another case comes along and becomes the latest case, which has the benefit of legal analysis.
Great. Okay, so that was me and Keith Gordon discussing the Upper Tribunal case of Kickabout. Thank you very much, Keith. Good to speak to you today.
Bye.